Abbreviated one. How are y'all? Good afternoon. Thanks for coming out to FedSoc's first event in person since well before the pandemic started.
2019.
2019. So we have, yeah, go ahead, give applause. Not to mention before that, St. Mary's FedSoc was fairly small, and I don't really know what events we did prior to that. So we're glad to be back. We're glad to have a diverse group of people here on thoughts on political spectrums. That's the whole mission. I'll read a brief little statement to help familiarize our one other FedSoc, though it's a little crumpled, I apologize. The Federalist Society for Law and Public Policy is a group of conservative and libertarians interested in the current state of the legal order. It's founded on the principle that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The Society seeks to both promote an awareness of these principles and to further their application through its activities. We're excited to have Professor Josh Blackman, who's a national thought leader on constitutional law and the United States Supreme Court. Professor Blackman's work was quoted during both the presidential impeachment trials. He has testified before Congress and advises federal and state lawmakers. Professor Blackman regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Professor Blackman is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. In 2009, Professor Blackman graduated from George Mason School of Law. Following graduation, Professor Blackman clerked for the Honorable Judge Kim R. Gibson, U.S. District Judge for the Western District of Pennsylvania, and clerked for the Honorable Judge Danny J. Boggs for the United States Court of Appeals for the Sixth Circuit. Since 2012, he has served as a professor at South Texas College of Law in Houston. He's also an adjunct scholar at the Cato Institute. Professor Blackman has authored 3 books, and his latest is an introduction to constitutional law. We are excited to have Professor Blackman here to come and talk to you today about Model 8.4G, as well as how it plays with the First Amendment. Without further ado, Professor Blackman,
Thank you
Mike is
so
yours.
much.
Thank you for coming.
Thank you. Thank you so much. It is so good to see live faces again. How many of you are 1 Ls? Okay, 2 Ls? 3 Ls. Okay, so those 3 Ls, you know the before times, right? You remember what it was like to actually have in person. The 2 Ls don't know, and the 1 Ls are just getting started. So this is what law schools usually like. You have organizations, they bring in speakers, there's sometimes food, although we don't have it today. We're getting it, don't worry, we're working on that. And you're exposed to ideas that you may not otherwise be exposed to in the classroom. You may not even be familiar with what the Federalist Society is. I've been a law professor in Texas for nearly a decade, and I've never been to St. Mary's. I've been to every other law school in the state except for this one. So let me just take a few minutes and discuss what the Federalist Society is, why it exists, why I decided to take a 1-hour Southwest flight today to get here and right back and afterwards. The Federalist Society is a group of conservative and libertarian attorneys who are interested in debate. And I mean that sincerely. It's not about identifying a single position that everyone must hold. Federalist Society members have a fairly wide range of views, and we often have debates. Now, we were not able to find a faculty member to participate today, unfortunately. Usually we have debates. Maybe we have some later this semester. One of our core tenets that Federalist Society members care deeply about is free speech. And free speech means a lot of different things to different people. But one element of free speech is the ability to come here and speak on contentious matters of public concern. You can sit here, you can ask whatever questions you want, but we can all have a good discussion. But there are often threats to free speech that might not be obvious. And you might think that certain policies are actually good, that in fact limit speech in dangerous ways. And that leads me to the topic for discussion today, which is American Bar Association, ABA, Model Rule 8.4G. Many of you have not taken professional responsibility yet, I'm assuming. You'll take it soon. You'll be lawyers soon. And as attorneys, you have to follow certain rules. Texas has rules, New York has rules, every state has rules, which are fairly similar, but there are some nuances from state to state. The American Bar Association puts out what they call the model rules. These are rules that other states can emulate. Most of the rules are not controversial. For example, lawyers can't steal. Good rule, right? By the way, the easiest way to get disbarred is to steal your client's money. Don't do it. Don't take money from one account and put it into your account unless you have permission. That's the quickest way to lose your license. You'll see the Texas bar sends out a journal every so often. There's a list in the back of people who got disbarred. And I swear, trust me, the quickest way is commingling funds. That's what they call it, commingling funds, where you sort of mix money. Don't do that. Okay. Other rules are don't lie to a court. Good, right? Don't lie to a court. That's very bad. Don't cheat your client. Good idea. Other rules get more controversial and sort of harder to apply. Attorney-client privilege. You'll learn about this, right? If you have a client in one case and then you have a client in another case, if their interests are at odds, you can't represent both of them. Those are harder to apply, but still very important, right? And then there's some more general rules, about how you keep funds, how you keep documents, right, and so on. But there are other provisions in various state rules that permit discrimination. So, for example, you can't, fire an employee because of his race, right? That goes against rules of ethics and goes against local discrimination code. You can't, for example, during a deposition, start using a racial slur to demean someone, right? You're probably not going to be allowed to do that. But the rule we're talking about today is a little bit different. ABA Rule 8.4G doesn't govern the legal practice itself or the management of a law firm. Instead, ABA Rule 8.4G governs conduct related to the practice of law. And that's the key phrase, conduct related to the practice of law. That includes obvious things like representing clients, interact with witnesses, and so on. But it also includes social activities in connection with the practice of law. So, for example, if you have a continuing education class, right? You're on law school now. When you graduate, you'll need to take CLE. Every year, a certain number of hours of continuing education classes. Someone like me will come over and talk to you for an hour and you get credit. That would be conduct related to the practice of law. You also have what you might call a bar function, right? Where the Bexar County Bar Association has a dinner, right, for the members of the bar. Or you go to the Texas Historical Society dinner, okay? So you have various social activities that would now be under the scope of the bar's jurisdiction. Now, what does this rule actually say? Under this proposed rule, it is misconduct to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination. Again, so bars, harassment or discrimination, not the same thing, they're different, on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, I'm out of fingers, or socioeconomic status, 11. So there are 11 bases in conduct related to the practice of law. So let me read it again, just shorten, right? For conduct related to the practice of law, you can't engage in harassment, discrimination, any of these bases, right? I don't have much objection with the discrimination part. If you're subject to almost any jurisdiction in the country, if you're running a law firm, you can't discriminate. You have federal rights, Title VII, the Civil Rights Act, you have Texas law, that's fine. The difficulty does the term harassment, right? What is harassment? Now, you may think I'm sorry, I wasn't asking.
No, I have a question.
Okay, can we take questions till the end? Thank you so much. No, I'm happy to take your question. I promise we'll do plenty of time. So the term harassment is a term that's known well in sexual harassment law, right? Which is severe pervasive conduct that has a sexual nature. But the rule defines harassment differently, right? And it says harassment can be speech that someone can find derogatory or demeaning, right? What is speech that someone can find derogatory and demeaning? The bar rule doesn't really explain what this term means. So we have a long history of rules barring discrimination and rules barring sexual harassment. And I don't take any objection to those. But this rule is different because it would bar harassment, which means demeaning or derogatory speech. Okay. Again, and it applies not only in the legal workplace or the courtroom, but it governs in social activities. All right. So far, this rule has proved to be extremely controversial. The model rule was proposed in 2017. And since then, only 1, 2, or maybe 3 states have adopted, depending how you count. 6 states have formally rejected the rule: Arizona, Idaho, Montana, New Hampshire, South Carolina, Tennessee. 3 states put out petitions, but they withdrew it. It was Nevada, Louisiana, and Alaska. In 3 states, the comment period, it closed without any decision. DC, New Mexico, and Utah, meaning it's been sitting there for almost 3 or 4 years at this point. Vermont adopted the rule in its entirety. 3 states adopted the more narrow version of the rule: New Hampshire, Maine, and Pennsylvania. I don't count Pennsylvania because a federal court declared it unconstitutional. So at the moment, that doesn't really count. That's still in litigation. It's under consideration in New York. Texas, where I think most people probably sit for the bar in some period of time, whether they appointed a committee to study it. If you know anything, when you appoint a committee, that means you want to die, right? When you put it into a committee, that's simply kill it. But I think it would have a very hard row in Texas. The Attorney General has deemed the rule unconstitutional, and so on. I filed a number of letters in various states raising constitutional concerns with this rule, and those are some of the concerns I want to talk about now. So first, welcome. So first, one of the biggest difficulties with 8.4G is this concept of harassment in conduct that's related to the practice of law. Lectures, me speaking, given at CLE events would be covered. If you're at a dinner table and having conversation with people at a bar function, you're covered. If you know or reasonably should know that your speech might be found to be derogatory, this threat of sanction will chill speech. And let me just give you a few examples of how this could work. So imagine a speaker is talking about affirmative action, and he argues that affirmative action is actually harmful to minorities because it creates a mismatch between their abilities and where they're placed. Now, somebody might say, oh my God, that's such an awful idea. That's the point, right? If you know that your idea might be deemed demeaning or derogatory to someone on the basis of race, you could be subject to liability. Or perhaps you want to talk about Title IX, which is another issue, and you think the various campus procedures for discipline violate the due process clause. That should be right to cross-examine a person who files a sexual harassment complaint under Title IX. Someone might find that demeaning on the basis of sex. Or maybe you argue that gay marriage decision in the Supreme Court was wrong and that there's no right to constitutional gay marriage, right? Someone might find that derogatory on the basis of sexual orientation or gender identity. You can say that there should not be a bathroom policy to accommodate transgender students, right? Someone might find that demeaning on the basis of gender identity. I deliberately pick provocative examples to illustrate a point. We live in a society where people don't agree on a lot of very contentious social issues. But this rule would allow the bar to impose discipline for those who take certain positions at these events. This leads to a chilling of speech. And again, historically, the bar has regulated the legal profession. It's regulated, for example, depositions, court hearings, and the like. But what 8.4G does is intrudes further into the personal sphere. Okay? The bar historically has looked at Do you have a connection to representing clients? Are you fit to be an attorney? Are you frustrating the administration of justice? But 8.4G sweeps much more broadly. Now, I don't object to a lot of the elements of this rule in the abstract. Discrimination is already illegal under state law. If the bar wants to simply say it's unethical to violate state law and discrimination, I think that's probably okay. But it's this further movement towards the social events that's problematic. But when you're an attorney, you don't have the full complement of free speech rights. You can't go up to a judge in a court and say, Your Honor, you know what? F you, right? You can get thrown in contempt for doing that, right? You'll be thrown in contempt, and you should be, right? You can't walk into a deposition and start, hurling racial slurs at a witness, right? You can't be conducting voir dire, right? You can't be conducting voir dire and make overtly racial statements. In fact, you'll probably get yourself suspended for doing that, right? So you're seeing lawyers can have their speech restricted. Another area where lawyers can have their speech restricted is for advertising. It seems kind of almost stupid because who does this? But there actually are fairly strict rules of how lawyers can advertise themselves, right? You can't make claims and say things, I'm an expert in the death penalty. You've never tried a death penalty case, right? You can't say whatever you want. There are even restrictions on how much you can advertise your pricing. That is how much you charge for your fees, which doesn't sound very important, but there are actually limits on what you can say you charge. So there are lots of rules in which attorneys are able to, which the state can restrict an attorney's speech. But those restrictions usually govern things that are closely related to representation of clients and to prevent fraud and the like. In recent years, the Supreme Court has sort of shifted in a different direction. The court started to say that there's not some sort of category of, quote, professional speech that is beyond the scope of regulation. And there was a very big case from 2018 called National Institute of Family Life Advocates versus Becerra from California. You may have read about this case. California enacted law that required so-called crisis pregnancy centers, right? These are centers that do not perform abortions, but they try to provide services to pregnant women, for example, getting sonograms, offering information about adoption, et cetera. Right? California said that these centers were required to post information on their wall to advertise where an abortion could be obtained and that state funding was available to perform an abortion. These clinics challenged this rule as a form of compelled speech, that they're being forced to endorse or refer people to abortions, even though they found that abortions to be abhorrent. The court ruled in favor of the clinics. And the courts held that even though this is a medical practice or even a quasi-medical practice, they still have free speech rights and they can't be compelled to engage. This decision, I think, is very significant for 8.4G, right? The government doesn't have, quote, an unfettered power to regulate the speech of lawyers simply because they provide services with a professional license. Lawyers do retain free speech, right? We're not talking about fraud or some sort of conduct that's important. This is sort of speech related. Okay. More recently, a federal judge in Philadelphia declared unconstitutional Pennsylvania's rule. And I just want to read you a passage from that opinion. The court said, there is no doubt that the government is acting with beneficent intentions. And I believe that. I think those who favor this rule truly do have beneficent intentions. However, in doing so, the government has created a rule that promotes a government-favored viewpoint monologue and creates a pathway for its handpicked arbiters to determine without any concrete standards who and what offends. Right? Offensive speech is protected by the Constitution. flag burning is protected by the Constitution, right? We go down a very dangerous road when we say that speech that merely offends should be removed from the body politic. Protesting at a funeral is an awful thing to do. Awful. But it's protected. And we protect free speech precisely because you only get to do that once. Once you allow certain ideas to be beyond the scope of acceptable discourse and the state can punish it, you can't go back upon it. Free speech is something that can only be lost once. And in my line of work, a lot of what I do is saying things people don't like to hear. We were nodding. I know. But I appreciate the chance I can come here and speak to you about this. I will take questions in just a moment, I promise. If this sort of rule was enacted, I would be in a much tougher spot. Every time I walked into a classroom, every time I walked into a lecture hall, I would have to think twice and say, could someone find my speech demeaning or derogatory on the basis of those 11 things I mentioned before? And if the answer is maybe, then I might be subject to a bar complaint. And maybe you don't know how bar complaints work, right? Most bar complaints are simply dismissed out of hand, right? They don't go anywhere. Any of you can go tomorrow, file a complaint with the bar. They'll investigate it maybe in a year or two, and nothing will happen, right? These things take forever. Unless you steal your client's money, that's an easy one. If you steal money, they're going to nail you right away. But if it's something more, nebulous, it'll take forever. But I'm a tenured law professor. I really don't care. Let's say you're a first-year associate, and someone calls your partner and says, "Hey, I just filed a bar complaint against him." Bye-bye. Yes, that's a nice job you have there. The costs of a complaint are significant because your boss may just say, "Forget this. I don't want to employ someone with a bar complaint against them," and you lose your job. So we're talking about a serious sanction. Defenders of 8.4G usually say, "Don't worry, trust us," right? We will enforce this rule consistently. In fact, in the Pennsylvania litigation I mentioned a minute ago, the head disciplinarian filed an affidavit saying, "Don't worry, I will not use this in any way that violates free speech," which is, it's better than nothing. But when it's your license on the line, those sorts of assurances are not very positive. I'll read one more sentence from the Pennsylvania judge's opinion, then I'll open for questions. The judge wrote, "Our limited constitutional government was designed to protect the individual's right to speak freely, including those individuals expressing words or ideas we abhor. The bar should not be used as a tool to punish speech we abhor. Use other mechanisms to deal with those issues." Thank you all so much. And I think my friend over here has the very first question. I appreciate your patience. Thank you all so much. You can clap, that's fine.
So how discrimination can be speech or conduct though? So how is that, what is an example of discrimination that, could you give me an example of discrimination?
Sure. I am firing you because of your race, right? That's a type of employment action, or I'm not giving you a promotion, or I'm demoting you, or something, right? Usually discrimination means some sort of employment action. What I think you're asking is, what if you're in the workplace and you say, you are pick your racial slur, right? That's speech. Employment law permits punishment for speech, but it usually has to be what's called severe or pervasive. It has to be some sort of ongoing pattern or a single comment that's extremely egregious. Usually incidental comments that may find demeaning are not enough to trigger employment discrimination laws.
Okay. I also have several other questions, but I don't want to take up.
Or I'll tell you what, let me call on someone else and I'll come back to you. How about that? Okay, other questions? Yeah, right over here.
So is there I might have missed this. Is there a definition of what related to the practice of law means?
Yeah, let me give it to you. Related to the practice of law, it's a long definition. I just want to make sure I give it to you correctly. Includes representing clients, okay. Interacting with witnesses, coworkers and court personnel, okay. Lawyers and others. And others, who's others, right? lawyers and others. So the first two are fine. It says interacting with others. So we don't even know who that is. So that can be basically anyone, right? You know, if you're in a cab on the way to a deposition, is that as a cab driver an other? I don't know. Operating or managing a law firm, that's okay, that's fine. And then the last one, participating in bar association, business, or social activities in connection with the practice of law. That's the last one is actually the most significant. Yeah, go ahead. You follow?
Yeah, so like for instance, let's say you're on TV representing yourself as an expert who is a lawyer, and you say something that would that be related to the practice of law?
Could be. Yeah, I mean, let me give you sort of a rip from the headline examples. So you all know Rudy Giuliani, who was President Trump's attorney in various regards for the last couple of years. I'll just leave it at that. He was actually suspended from the New York bar. The former U.S. attorney for the Southern District of New York was suspended from the bar. And it wasn't really based on things he filed in court. There was one court filing they found objectionable, but the bulk of the termination was actually for Giuliani's speech on TV, radio, and otherwise about the election. And I'm not exaggerating too much. There was another lawyer, his name is John Eastman. You may know the name. He was a law professor in California. He was also one of Trump's attorneys. And Eastman spoke at the January 6th rally along with Rudy. And there's actually recently a bar complaint against him to remove him from the California bar. And the argument is that he, just don't follow this, he discussed election law to the crowd assembled by the White House, right? And the complaint says he was giving legal advice to the mob. So you asked me a question about TV. So I'm like just leveling up on your question, right? What is the definition of practicing law? It's actually a really hard idea because often attorneys, you'll be counselors very soon, God willing, you'll pass the bar. Your jobs are going to be very broad. Some of your arguments are to judges, right? Some of your arguments are to perhaps a mediator. Some of your arguments can be to a reporter trying to keep your client out of the headlines. Judges can't lie to courts, right? That we all agree it's a bad thing. Can lawyers lie to the press? Can they mislead the press? Is that obstruction of justice? Right? These are actually very, very tricky questions. Like, do you have a duty of candor to a reporter trying to destroy you? Right? What job is being a spin master, right? You go on TV to try and do damage control for your client. You have to tell the truth. Defining the bounds of where legal practice is very, very hard. I don't even want to touch that issue today, but I want to say is if a person's at a dinner table conversation, that probably should be beyond the scope. If a person is simply giving a CLE lecture, I'm up here, there's no CLE here, but in theory there could be, that should probably be on the scope. All right, let me go back to you, then I'll do another one.
Why is the action of a state bar considered state action?
Oh, really good question. In every state, usually it's the state Supreme Court grants a monopoly, right? So for example, the Texas bar is the only bar in Texas, right? I can't decide to create the Josh bar and I'll start licensing attorneys in Texas. It won't work. So because the state gives the bar this monopoly power, it's considered a state entity, right? It's almost like think of like a regulated railroad, like a common carrier type thing. Maybe use an analogy from torts, right? When the state gives this monopoly, it's considered state action. Good question. Thank you. All right. Yeah, over there. What's your name?
Yes, sir.
Yeah, right there.
I'm coming to this from the perspective of the left, and I myself am a supporter of some controversial ideas like the BDS movement and Israel's treatment of Palestine. Here in the state of Texas, there were laws passed that kind of prohibit contractors from, I guess practicing in a form of political speech. So how should I, from the left, be worried about this rule affecting me? I'm just kind of curious as to maybe how I might interact with these problems.
Yeah. So let me give you another example just to might illustrate your question a little more clearly. This rule is not only going to be used to sort of troll conservatives, it'll be used to troll liberals. Let's say you were to give a CLE event on BDS, right? And you were to say, the The BDS movement it's not about anti-Semitism, it's not about Zionism, it's about stopping oppression of Palestinians, right? That's your position. And then some of the complaint says you not discriminate on the basis of religion against Jewish people, but you be subject to a complaint. We live in a world where robust discussion of ideas is often very disconcerting. In fact, often the only way to get someone's attention is to sort of shock them, right? If we all just sort of go along and like, hey, la, 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 so just very gentle, whatever, people kind of ignore you. But if you want to grab someone's attention, sometimes you have to beat them over the head with it. Not literally beat them in the head, but use speech that gets their attention. And if we start turning to the arms of the state to prevent that sort of shock value, I think we're all poorer for it, right? You have your views on BDS, she has her other views on Israel, whatever. Let's argue it. Let's enact statutes. Let's debate it, but don't throw people into disciplinary proceedings because of it. I'll try another one. Excuse me.
For things like microaggressions, which I would consider discriminatory, those don't merely offend. There's significant research that demonstrates the detrimental impacts on a human's ability to thrive in a situation of which they're confronted with one microaggression or many.
Mm-hmm. Sure. Right. So I'm sure most of you know the term microaggression. I don't have to define it here. The concept of microaggression doesn't actually have a analog in federal employment law, right? So the usual term is speech must be severe, pervasive, right? And the very nature of microaggression is it's usually not severe, pervasive. It's some sort of like kind of either an offhand comment, it can be unintentional, right? So I don't think under current employment law, microaggressions would actually give rise to liability. But that actually wasn't your question. Your question was, the term offense is perhaps a little bit too generic, right? Speech and conduct that you may think is trivial could indeed have a detrimental effect on a person, even if you don't know it, right? You might say something and think it's completely like innocuous, and then the person receives it and actually has harm. And the studies you show can back this up. So I think what we have here is sort of this sort of trade-off, perhaps, right? If we live in a world where these sorts of microaggressions are sort of expelled from the body politic, it also requires sweeping a lot of speech that might be desirable, right? So to use the BDS example my friend mentioned a minute ago, if we start enforcing legal professional rules in such a robust manner, we're going to chill speech that you might in fact find desirable. So in order to have a robust debate, we might need to let microaggressions go unpunished, even with those detrimental effects, and which is not a particularly desirable answer. But usually in our society, we put the thumb on free speech more so, which might not be the best answer. I'll come back to you and someone else. I'm happy to do this ping pong. All right, other questions? Yeah, Corey, go ahead.
So what's the burden we get to? What line of speech becomes discriminatory? You may have hit it earlier, but where is that line once you cross in this model rule we're the ones that adopted? When I say something that's right up the line, what crosses that line? Is that just sort of board discretion? Or how does that roll through? And how do we make sure it's not a fraudulent speech?
Right. So if you couldn't hear, the question is, how do you draw the line, right? Line drawing in the free speech context is really hard. Precisely because of the reasons you mentioned a minute ago, one person's definition of offense is different than another person's definition of offense. If you read the Philadelphia judge's opinion, which I won't, it's long, but I'll paraphrase it for you. The thesis is we can't give the government the power to define what's offensive because that can be used in a punishing way. So I'll take your point at microaggression. I'll just take your point as it was stated. People are going to be exposed to things that are not good for them. They may not like it. But the cure is worse than the disease, right? The process of eliminating these sort of harmful statements, the cost of that elimination is far greater than the statements themselves. And again, people may not agree with that. But the history of this doctrine is to favor free speech. Yes, back to you. And what's your name again? I'm sorry, I didn't get your name in for them.
Natalie.
Natalie, okay, back to Natalie, please. Go ahead.
But with microaggressions, they specifically work to limit the diversity of the bar, which then contributes to groupthink. So it's not really helping anyone. Like the microaggressions aren't contributing content to the conversational discourse in any meaningful way. It's actually making it worse for everyone involved. So why even keep it at all? If it's literally holding everyone back.
Right, but so let's say when you say why keep it, the thing what you're saying is why don't we eliminate it or punish for it? And the point is, if you punish just those microaggressions, you'll sweep in a lot more, right? So I don't know how much the microaggressions inhibit the bar, but I would think if we start telling lawyers the things they can and can't talk about, it would do far more damage to the profession. But that's the thing, the judgment which we could disagree on, I suppose. Okay, let's try. Maybe someone new hasn't raised their hand yet. Yeah, right there.
So your opinion, do you think we should narrow words that are ambiguous in this rule, or do you think we should eliminate the rule?
Yeah, it's a good question. So I can go either way, right? I've actually I've written letters to a number of state bars saying, here are changes you can make that would bring this rule into compliance. And a few bars have actually said my ideas were like worthwhile. They didn't adopt it for the reason they said my suggestions were good. One way to cure this, I think, would be to impose a severe pervasive requirement. This is a phrase I keep using, right? If you engage in speech that's severe pervasive, that could, I think, give rise to liability under the bar because it's consistent with federal law. A single lecture at a bar event or a single offhand comment at a dinner table should not be grounds for discipline. If you engage in actual sexual harassment, as a term is defined in 5 decades of employment law, okay, yeah, I mean, that's fine to impose liability. I would expressly eliminate the social functions from this rule, right? I think that would cure it. But let me just tell you why my idea is not well liked. A lot of sexual harassment happens after hours. I think we have to be candid about this, right? If you're a female associate and some guy propositions you at a bar at a bar function, if there's a bar function at a place where you drink alcohol, a bar, right? That might be enough, right? If you're in a limousine ride back from deposition and some partner says, come back to my hotel room, that probably would be enough to trigger discipline. So I understand why they want the rule in there to be about social functions. I get why that was put in there, but I think you could use a severe pervasive requirement to go beyond this and not merely have demeaning or derogatory. That's a vague term. That's not enough to pass muster. Okay, I think your hand, and I'll come back to you. Yeah, go ahead.
When I heard that the socioeconomic thing could even be used, I'm thinking like if I'm a lawyer, I can't, saying things like eat the rich or
well, isn't that right? I mean, yeah, it's a good point. So let's imagine you're the Bernie Sanders law firm, right? And you say I will not hire anyone who makes more than $100,000 a year, right? I will not hire anyone who came from money. I want people who are first-generation Americans. You've actually violated the rule. Let's say that you work for a different law firm that manages trust funds for billionaires, right? And you say, look, we have a certain clientele who have a lot of money. It's not me, right? I'm not getting hired there. We want to hire people who have experience dealing with money. That would be violating this rule. So the socioeconomic one of all the 10, that's just the craziest one. That's a very strange one, and most state discrimination laws don't include socioeconomic. But
and I guess the point is that depending on which side you look at it, that this law or this model rule could be cynically kind of wielded against anybody, depending, because right now I think the hierarchy here in Texas is conservative. I see a target on my back, right? Being someone from the left. But I could totally see a conservative, let's say Illinois, or seeing a target on their back because the hegemony there is more liberal, I guess.
Yeah, I mean, let me just make a broad point. I'll come to you in a minute. Usually, the people who want free speech are those who are in the minority, because if you're in the majority, you're fine. If your views are in the mainstream, you don't really need the First Amendment, Think about it. Like if everyone agrees with you, you don't need to fight for your right to speak. Usually those who are complaining about free speech are those whose views are not in the mainstream. So my friend over here in Texas, if you're a liberal, mazel tov, you're out of the mainstream and you need the First Amendment. When I go to California, if I go to New York, I'm getting protested, right? I'm in the minority, right? So it sort of varies depending where you are. And that's why giving up free speech assumes you always be in the majority. Maybe in 20 years, you'll be in the majority. Texas turns bright blue, and then I'm sent off to a gulag somewhere, in Brownsville, right? I don't know. It's nice down there. So things change quickly, and you never know which way it changes. I'll come to you, and then a question over there. Okay, Natalie.
All of this assumes that the climate of which that exists and that cultivated a jurisprudence that allowed really expansive free speech, it all assumes that all of that jurisprudence is sound, that all of the jurisprudence that allowed hateful speech or really awful things to be said or pinned really awful things and opinions were acceptable ways of interacting with the community. And why continue to just work, like why not question that might not be the way to do things? Why not question, well, maybe this kind of speech shouldn't have any place in professional or societal settings?
Yeah. I mean, I take Natalie's question well. I mean, the United States has been an outlier. If you go to most countries in Europe and otherwise, free speech law is not the same. There's hate speech prosecutions. Libel and defamation is very different. If you want to protect your reputation, go live in Europe, right? You can sue for libel on just about anything. It's much easier. Much of our free speech jurisprudence was actually created during the Civil Rights era, during the 50s and 60s. And to the point he asked me a minute ago, it was used to protect minority speech, right? Classic case, NAACP versus Alabama. Very famous case, you maybe read about in the First Amendment. Alabama said, we want all nonprofits to disclose their membership lists to promote organizational needs, right? Well, come on, give me a break, right? They wanted the member list of the NAACP to intimidate and harass their members. And, if you are turning over your membership list, that list can, be leaked, and then those people can have their houses burned down, right? This was not a joke, right? This was an actual issue where the First Amendment was sort of life or death. And the court held, no, Alabama, you can't forcibly disclose the membership rosters, right? So, I mean, I take your point. The jurisprudence may not be sound, but developed in an era where a very different sort of group was being protected. Today, it's almost like a reversal where it's conservatives who are sort of screaming, First Amendment, First Amendment. And I think that's because increasingly conservatives are in the minority in many states, and their views are out of the mainstream. So there's been this shift in reversal, where in the 70s it was, let's defend the Nazis marching through Skokie, and today it's, let's throw the Nazis in jail in Charlottesville. We've had this sort of flip in the world. I saw a hand over there. Yeah, right over there, and then over there. Yeah.
So I'm just curious, isn't this just kind of bound by what capacity you're acting in? So for instance, if I am at an ABA function, of course I would be held to the standards set forth by the ABA. That being said, after I get my law license, if I'm acting as this guy's campaign manager, would my official capacity be just, be his right-hand guy as far as either persuading or intellectually combating certain conservative ideals? So for instance, you coming to us to talk as a member of the Federalist Society, wouldn't you in a sense be exempt since you're acting as a speaker versus as a lawyer?
You'll learn this when you pass the bar. You are a lawyer 24/7, 365. You always are. I'm not being facetious, right? Trust me on this one, I promise. You'll be doing something and someone says, hey, you're a lawyer, let me ask you a question, right? The second you answer this question, you become his lawyer, whether you know it or not, right? An attorney-client relationship is not formed when there's paperwork. That's not, if he thinks that you formed a relationship, you just form a relationship. And with that comes the conflicts and everything else. So if you're an attorney who's a campaign manager, perhaps you could be viewed as giving your client legal advice, and then all the rules that come with it. In fact, that's the reason why becoming an attorney limits your ability to agitate. Is that the word, right? It's hard to be an agitator when you're an attorney, right? You represent the agitators, you can't agitate yourself. Do you have a follow?
I do have a follow-up.
Please.
So how does that apply to the numerous members of Congress who are themselves attorneys, or for instance, our governor, who is an attorney? So again, I guess I'm just curious where the line ends with employment capacity versus you got a JD at the end of your name now, so therefore.
Look, a lot of the people in government go on inactive status. Yeah, they don't keep up with their CLEs. I don't know if Abbott keeps active. Maybe is he active? I mean, he's a former Supreme Court justice, but there are risks. If you can be seen as you're working for a client and advising them, it can be seen as legal representation. They're right over here.
I guess this is another question. I mean, it would seem to me that a climate that allows its jurisprudence to be, the soundness to be questioned itself, allowing the exercise of free speech. To your point, like one sound is gone, then whoever ends up in control at that time would kind of control.
Yeah.
The allowance of speech. And kind of to one of your earlier points, I mean, the shoe really is on the other foot sometimes. Again, like 1950, Buckley and Goddard and Yale was saying that academic freedom was, a code word for
Communism.
teaching
Yeah,
communism
exactly.
schools.
Yeah.
And now National View, everyone in there will say that academic freedom.
Yeah, go cross yourself. Yeah, exactly. I mean, look. Again, free speech is a funny way of switching over time, right? It protects those whose views are the minorities. In the 50s, 60s, if you were a socialist on campus, you needed the First Amendment, otherwise you'd be expelled and you would be denied your citizenship and you restrict your citizenship. I mean, things were very different back then, right? And today, most campuses are pretty much to the left. I don't know your campus well enough, but I'm guessing it is. That's why I'm brought here as a ringer. That's why I take Southwest flight number 1. It's called flight number 1. That's from Houston, San Antonio in the morning. That's why you're brought here. But you're right. Once you give up on free speech once, it's gone. It doesn't come back. And I can list country after country that sort of surrendered it and then was lost. Okay, go ahead.
Here's for the defenders of the rule, and we're trying to push back at people like the Federalist Society or others that I'm curious as to what is the defense of it and what do they say about your criticism?
Sure. The number one, I've debated this topic a half dozen times, so I can tell you what their points are. The number one position is trust us, right? We will not use this rule in an abusive fashion. The number 2 rule is stop being so dramatic. We're not going to come after debates on affirmative action. We're not going after debates on gay marriage. We're trying to go after sexual harassment. The third primary response is even if there's some problems with the rule, it can be settled in litigation. So in other words, if a frivolous bar complaint is actually filed, you go to court and you say, Your Honor, this is a violation of the First Amendment, the judge throws it out. So if you think of common law, the difference between a facial challenge versus as applied, like, look, if there's abuse, just deal with it later. Right? So those are the 3, I mean, I debated this. I could debate myself on this if I wanted to. I could go both sides. But those are the 3, I think, biggest responses. My general response to that is, right, the courts will not tolerate a violation of free speech. But a lot happens before you get to a final judgment of court. So first, people might censor themselves. They'll say, you know what, screw this. I don't want to deal with liability. I just want to say what I want to say. I want to talk about BDS, whatever whatever your cause is. Second is, if you're a junior associate and your boss finds out you have a bar complaint pending against you, you're going to lose your job. Getting a job is not easy. Maybe some of your 3Ls have jobs lined up. Good for you. Not everyone has that. And if you know that there's a bar complaint hanging on your head, or if the person who files it calls your managing partner, you might be in trouble. So even having the existence of this platform, I think, is risky. I don't buy the trust us. Yeah, I don't trust people. All right, I know you guys have class at 1, so maybe 1 or 2 more questions, and so we get you up time. So, Natalie, do you have anything else you want to ask? I make sure I come back to you. All right.
Just hypothetically, I'm a lawyer in my Twitter bio. I'm out there having some mean tweets, and I'm in a jurisdiction where I'm subject to a version of 8.4G. What is the worst that can happen to me? That's offensive.
Right. So the question is, if you're a lawyer and you have a Twitter account, it says lawyer in your bio, in your Twitter line, and you have some mean tweets. Yeah, there have been attorneys who've been suspended because of Facebook posts and tweets. So yes, even before 8.4G. I mean, look, I think it's this goes back to the advertising point. When an attorney has a Twitter account, is that a form of advertising for his law firm? If the answer is yes, then you're subject to a lot of rules governing fraud, right? You can't make representations on your Twitter page like, I'll get you out of jail, right? I will get that ticket canceled. People say these things on billboards, right? So it's risky. I will make sure you get out of jail, okay? No, you can't do that. But what if someone posts a thing saying, Blue Lives Matter, right? Ooh, I said it. Right? Sorry. What if someone says, you know, the George Floyd verdict was wrong? I said it. Right? It's a legal opinion. People can find demeaning. There's a lot of speech that could be deemed offensive, and especially God, with social media is the worst. I don't check my Twitter anymore. I quit Twitter 2 years ago. I'm such a happier person for it. Get off while you can. It's dreadful. But people say and do dumb stuff on Twitter on a minute by minute basis. And look, tweets last forever. When you delete a tweet, it's not gone. People screenshot everything. They screenshot everything. So once you hit send, it's gone. Maybe one more question, then we'll wrap up so you guys can get to class. Yeah? No?
I was just wondering, is there any precedent that would like help define like words like demeaning and derogatory, or is that just words they just pulled out of nowhere?
They use a dictionary, and that's that. You know, they basically look for synonyms of offensive, and they look at demeaning and derogatory. Again, those words are used in various statutes, but when they're coupled with severe and pervasive, I keep coming back to that term. But good question. All right, Natalie, anything else you want to ask? Okay, thank you all so much. This was really fun. I'm grateful to this guy.
Can I do a photo real quick? Yeah, sure. Y'all like me? We can come here and get a photo of Professor Blackman. It's a group photo. The other thing I have to say, it's going to be a pretty quick next few weeks. On Monday, we have Ella Shapiro coming from Cato. He's going to be talking about the politics of the Supreme Court. I think it's going to be another fantastic speech. We want to see y'all here. There will be food at noon, same room. 2 weeks later, we'll have another speaker from Cato coming in and talk about what are we going to do after Afghanistan? Are we a broke empire? So I want to thank Professor Blackman again for coming in, having a fantastic speech, for kicking us off our first event in 2 years, and thank y'all for coming out.
Thank you. Thank you.
Okay.